Okay. Welcome everybody to the Millburn Township Planning Board meeting in accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975. Be advised that notice of this meeting was made by posting on the bulletin board at Town Hall and serving the officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place at the Millburn Board of Education Center building at 7:30 p.m. on September 17, 2025. A roll call, please.
Corey Biller.
Here.
Allison Canfield. Michael Cohen.
Here.
Jorge Mastro-Petro.
Here.
Deborah Neves. Here. Frank Sacamandi.
Here.
Michael Zion. Jonathan Baxter.
Here.
Sergey Sivstov. Sereni Vijay. Gaston Happert, Chair.
Here. And just to note, Allison did have a family emergency, so she's an excused absence. Okay, we have several things on the agenda tonight. We have an announcement, some housekeeping with approval of minutes. And I'm going to switch up the order a little bit and go with the resolution before we do the application and then end with our executive session. Our executive session, after our executive session, we will not be turning on, the camera will be off and we will not be turning on the camera for our Ethernet audience.
And if I may, Mr. we will only, the intention is only to come back into open session to have a motion to adjourn and formally close the meeting. No formal action to be taken thereafter is the intention.
Thank you. Mr. Warner, could you help us out with the announcement for application 25003, CCATS Fit LLC, preliminary and final site plan with C variance that will be carried to October 15th due to an insufficient notice?
That's correct, Mr. Chairman, and just to round that out, it'll be carried to October 15th, 7:30 p.m. at the same location, the Board of Education Center building. It was partially sufficient notice, but not fully sufficient notice. So to be clear, it's being carried with further notice to the omitted recipients, that being, as I understand it, the government and utility recipients on the tax assessor's lists, as well as perhaps also those residents of Springfield Township who are on the 200-foot property owners list. But those residents who received the certified mail notice, specifically, as I understand it, Millburn residents on the 200-foot property lists, will not be getting another notice. This is that notice that's being carried, as well as the publication notice was sufficient. So they'll be partially providing further notice, but not to all recipients. Those who receive notice and the publication, that is sufficient. So we are carrying that matter with only that additional further notice to the omitted recipients to October 15, 7:30 p.m. this same location, the Millburn Board of Education Center building.
Next order of business is the approval of minutes from July 30th. We split the meeting up into the regular session and the executive session. So first up are the meeting minutes for the regular session. Were there any questions or comments on that set of minutes? With no questions or comments, I'll make a motion to approve the regular meeting minutes for July 30th, 2025. Do I have a second?
Second.
All in favor?
Aye.
All opposed? Motion passes.
To be clear, I wasn't here, so I'm abstaining.
I wasn't here yet. And Sarah has running directions, as she well knows, to have any absent members listed as abstentions for all minutes. But thank you.
Okay, and for the second set of minutes, the executive session on July 30th, 2025, did you have any comments or questions? Okay, I'll make a motion to approve the executive session minutes for July 30th, 2025. Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Motion passes. Okay, on to our resolutions for this evening. We have a resolution for the denial of application for 2024-003 High Center for Living Judaism Incorporated. Mr. Warner, could you please take us through this, or do we ask for questions and comments? How do we?
What I would do is just state that I hope that the resolution is an accurate memorialization of the board's decision. 7-1, if I recall correctly, a denial of that particular application for preliminary and final major site plan approval conforming conditional use approval and the design waiver for the buffers for the house of worship at 165 Old Short Hills Road. And I guess I have one question, and that is, was it an accurate memorialization? Or does the board have any questions or concerns prior to a motion second and adopting that resolution? And I leave it to the board for the motion, the second, and the roll call vote on the adoption.
I'll make a motion to adopt the resolution for application 24003. Do I have a second? Roll call vote, please.
Cord Biller,
Yes.
Michael Cohen,
Yes.
Jorge Mastropietro,
Yes.
Frank Sacamandi,
Yes.
Jonathan Baxter,
Yes.
Gaston Halbert.
Yes.
So adopted, thank you.
Okay, we are on to our application for the evening, application 25001, our first application for the year. It's the Kennedy at Milburn LLC Woodmont Properties application 185 JFK Parkway, block 5302, lot 5 for preliminary and major subdivision approval. Is there representation for the applicant?
Yes, Mr. Chairman, thank you. Should I use the table or the lectern? Does it matter?
It's your choice. Most people use the lectern, but thank you.
Lectern it is. For the record, my name is Thomas Carroll. I'm with the law firm of Thowalla LLP, appearing tonight on behalf of the applicant, the Kennedy at Milburn LLC. It's a fairly straightforward application. It's just the subdivision. It's to create block 5302, lot 5.02. There would be the larger remaining lot 5.01. It's currently all lot 5. This one works, I think. Did you hear me okay?
Yes.
Was it picked up on the recording? We're good, yeah? Okay. Thankfully, okay. So the property is at 185 JFK Parkway. I'm sure you're all familiar with it. I guess the first order of business, we did provide notice of the application, filed an affidavit of mailing and publication with your board secretary, and I was finding of jurisdiction on it.
Mr. Chairman, happy to, as I always do at the front end, after council is introduced himself, I did have an opportunity to review the notice, found the content to be sufficient, found it to be timely served via the affidavit of service and publication. Certified mail was on September 4th, for the most part, and a little bit on September 5th, as well as I recall. And the publication was on September 5th with the Star Ledger. So all notice was timely, was all at least 10 days prior to this evening, the hearing date of September 17th, 2025. So in my opinion, the board does have jurisdiction to hear and decide the application.
Thank you, Mr. Warner, appreciate that. So, yeah, if I could just give some brief background on it, and then I'm going to turn it over to our engineer to actually describe the subdivision. The subdivision would create a new 8-acre lot. No variances are sought. The site, of course, the reason we're here, it's proposed that as an inclusionary development as part of your fair share plan for the third round, as memorialized to the settlement agreement and orders by the court in that case. One submission waiver was requested. That was for the sustainability checklist. And that waiver was granted since no improvements are proposed at this time. There's no perceived reason to do a sustainability checklist. Again, it's just a subdivision, not site plan approval at this stage. So, let's see, I guess I'd like to mark a couple of exhibits if I could. One being the settlement agreement entered into in the third round case, which describes the site and has some guiding parameters for the ultimate development of the site. And also the ordinance that was adopted as a result of those proceedings, ordinance number 2585-21. And I don't know what the board's practice is. Would you like me to hand mark them, give them to your planning board secretary?
You could, well, actually, Sarah, you could put the date and the designation of A1, A2 respectively to those two documents, with the chair's permission.
If I could approach, the settlement agreement, I guess, would be A1, and the ordinance 2585-21 would be A2.
And is the settlement agreement July 30, 2021?
It is, yep. The ordinance date, I think, was adopted November 9, 2021. So with that housekeeping out of the way, the settlement agreement and the ordinance I just referenced set up the overlay zoning through which the site plan application will ultimately be filed. Creates the overlay zone of RMF-AH3, which allows, of course, an inclusionary development, as I mentioned before. The property being purchased from the New Jersey American Water Company. And other than that, I don't know if I have anything to add. I guess the only thing I would add is the ordinance, page 10, paragraph 3, section 5, notes that this development is exempted from the town's tree preservation ordinance. And there's also some other language in there excusing the property from, what would deem to be cost-generative provisions. But for present purposes, there's no development actually proposed. And it's just, I think the only relevant exemption at this point is from that ordinance.
And if I may on that, Mr. Chairman, and I think you started to make the point, Councilor, and I would concur that to the extent that that's relevant, it's probably relevant at the site plan stage, not the subdivision stage, because I assume no trees are being addressed other than perhaps the paper to draft the major site, subdivision plat, unless it's digital, in which case we'll save that tree as well. But no trees are being addressed on the site unless and until we get to the site plan stage, correct?
That's correct.
Okay, and just for comprehensiveness, that exemption language, when we get to it at a later date perhaps, does have a however, and there are certain requirements for the benefit of the public to understand that with respect to landscaping plans and the planting of deciduous trees to the maximum extent possible and review by the township forester, so it's not as if it is an unqualified exemption, correct?
There is that, however, absolutely.
Okay, thank you.
So that's all really I want to throw into the mix at this point. And I'd like to turn it over now to our engineer, Craig Stiers, to actually show you the plans and mention a couple other things about the application.
And I'll, with the chair's permission, I'll swear in Mr. Stiers, as well as our board professionals, our engineer and planner. Mr. Stiers will be your only witness this evening, Mr. Carroll?
That's all I have.
Okay. If you'll raise your right hand, Mr. Stiers, and our planner and engineer, if you'll both do the same. Do all of you swear to God, all three, I should say. Do all of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Yes, I do.
Thank you all.
I have a easel here. Any particular place that you want to portray it?
just so that we can see and also the public.
Greg, I think you have a two-sided board, maybe just mark one side A3, the other A4, is that okay?
It is two-sided with the same image or?
No, different
Two different.
So just so that the public can see or our professionals can see as well what you're discussing.
Yeah, I'll orient you each one of them. A3 is a aerial photo showing the boundary of the property. It's dated today's date, and it is entitled Boundary and Partial Topographic Survey. And A4 is actually a replica, I believe, of sheet 3 of the plans, maybe 4. And it is also it's basically the smaller lot, the subdivided lot with an aerial behind it, just for perspective of what's actually out there.
If you could double check, I suspect it's the sheet 4, correct?
Yes,
Okay. And say, and I'm sorry, did you say when you say replica, can you be a little more specific as to
so it's sheet 4 with the aerial
superimposed?
superimposed.
Got it.
So I'll go back to A3, just to kind of orient you.
No, we qualified, Mr.
Yeah, please do.
If you don't mind, just briefly put your qualifications on the record.
Sure.
Engineer, surveyor, both, where are we going?
Just engineering.
Just engineer, okay, go ahead.
Professional engineer in the state of New Jersey. President Stires Associates, 43 West High Street in Somerville. Have been doing this since 1993. Our office is in Somerville, primarily around Somerville, Bridgewater areas, but I have testified before your Board of Adjustment a few times for variance applications, doing similar applications in subdivisions.
Licensed as a civil engineer in the state of New Jersey, remain in good standing,
That is correct.
and you've been accepted by several land use boards, including at least our zoning board of adjustment,
That is correct.
as an expert in the field of civil engineering, correct?
Yes.
We accept you as an engineer. Thank you.
Thank you.
Proceed.
Thank you.
Just to kind of reiterate, the existing site is known at 185 JFK Boulevard, lot 5302, lot 5 in the township of Milburn. Property currently contains 527 acres and currently houses New Jersey American Water operations and reservoirs, better known as Canoe Brook Water Treatment Plant. As you can see on A3, you can see the 2 reservoirs. The red line, you can hopefully see it where you're at, is the boundary of the 527 acres. At the lower side, you have the plant itself. That's pretty much the American Waters operations. Along bottom here is JFK Boulevard. And then once I turn it over, but the subdivision is going to be in this location here, which is the southwest corner.
Is it possible that we can move you out just a little bit? Are you guys able to see if you move out a little bit so our engineer planner can see? Is that, could you move the board out a little bit?
Mr. Sonic, you could move it back that way towards that wall and angle it a bit, so perhaps some of the members of the public and board professionals can see it while you're orienting. And members of the public are free to move their seat to get a better vantage point should they so desire.
Is that better?
Rotate that way, everybody. You can see.
Yeah, we should move the. Yeah,
I'm gonna get out of
that's
the
what
way.
I am, yeah.
That's what I do best.
You good on that side?
Okay.
Okay. You guys good? Okay. I'll back up a little bit. As you can see, the The red line is the boundary of the property, the two reservoirs, obviously sticking out. The, American Water plant facilities are in this location here. You have JFK Boulevard. This would be the location of the new subdivision line.
Apologize to interrupt, Mr. President, but if you could speak directionally south, southeast, as opposed to this, that, here,
Sure.
there.
Going back JFK Boulevard, going in east-west direction. The proposed subdivision line would be in the southwest corner of the overall property. Next door, you would have an office complex. Across the street, you have an office complex, and then obviously across JFK, you have the Short Hills Mall. That's the orientation. As far as what is proposed, the applicant is looking to subdivide 8 acres off that overall tract, again, which is located in the southwest corner. Then turn it to A4. And this is a blow up of that area, so you can see, again, JFK Boulevard going in the east-west direction across the plan. You have the red line, southern border of the overall tract, and then the line in blue is the 8 acres that is proposed to be subdivided. There is a small dedication as well, right-of-way dedication, because the existing property currently is in one of the lanes of JFK Boulevard, so the dedication would put that proposed right-of-way line just behind the curb line. And ultimately, that would be the 8 acres.
If I may, Mr. Chairman, is it 8 acres net of the right-of-way dedication?
Yes.
Okay.
Yes.
Not, thank you.
So in the end, it will be 8 acres exactly. And then the remaining land would be 519 acres. The remaining land would be proposed to be lot 501. The subdivided lot property would be 502. Again, to reiterate, there's no improvements at this time. And I think one of the comments from the planner's review was make sure that everything complied on both sides of the property. So there was a concern about the closest building to the proposed subdivision line. And that would be, going back to A3, would be the most westerly building of the American Water operations. To the proposed line would be 392 feet, so it's almost double what is required. But I think that's it in a nutshell, unless there's any questions. As far as the review letters, we've gone through the review letters. The engineering review is pretty much technical in nature and have no issues with that. We'll address all those comments, and the same with the planner's comments.
If I could, just one question, the application is in complete conformance with all applicable ordinances?
Yes,
Thank you. In other words, no variances are required.
that is correct.
I have a question. I don't think it's relevant, particularly for this discussion, but it just, out of curiosity, it says in the ordinance that the maximum lot coverage shall be 90%. If I look on the plan, it seems like more than 10% of the lot is wetlands, and well over 10% is inside the FEMA flood zone. If it subsequently gets, when it subsequently gets built on, do you know how the 90% is calculated? I mean, if there are certain parts of the lot that are automatically excluded, does that allow you to build 100% on the rest of the lot, or?
We were retained to do the subdivision mainly because, back in 2004, we did the overall tract for American Water. So at this point, there was just a subdivision, and to my knowledge, nothing contemplated as far as this application.
Well, I guess, yeah, well, there is something contemplated because the ordinance specifies that something is
And it'll be
contemplated in that ordinance. Yeah, no, I'm just curious as to how the denominator for that 90% is calculated. Is it the entire 8 acres, or is it the 8 acres less the unbuildable area?
I don't think we've analyzed that yet. I can tell you for sure, I haven't.
Okay.
Yeah, because we have no improvement shown, but yes, we'll obviously have to come back to questions like that.
Thank you.
Any other questions from the board?
Mr. Chairman, after our other professionals go, I may have a question or two. But if I may go last.
Okay.
I have no question, my question was answered.
Okay.
It's on the distance of the building.
Any comments or any discussion you'd like to have with the board?
No comments, no, we're here to answer any questions, of course.
Okay. Anything from our engineer? Excuse me.
The applicant has agreed to address all the comments in our letter, so we have, no other, comments, except for, once the subdivision is, revised, that a electronic copy is submitted, to the township.
No objection for that?
No.
And I'm sorry, can you just, both enter your appearances for the record, our board professionals, just so we have it on the transcription?
Graham Pedo, your board plan.
Christian Cueto, conflict board engineer.
Thank you. And just if I may, Mr. Chairman, just to round it out, the reports you were referring to that you're, on behalf of the applicant, you are stipulating to full compliance with same are the engineering report from Harbor Consultants dated September 16, 2025. That's one of them, correct?
That's correct.
And specifically 3, 4, 5, and 6 inclusive, as well as 7 are being agreed to, which at least 3, 4, 5, 6 appear to confirm what will be on the final plat when recorded, at least to this layman attorney's eyes.
Pretty good.
Oh, no, okay, thank you. So you're fully complying with that, and that's the date of the report, correct?
Yes.
And with respect to the planning report, that's planning report number 1, dated, for the record, September 11, 2025, correct?
Yes.
And specifically, the answer you gave to the question therefrom was with respect to item 3, A3 on page 4 of the planner's report, when you referenced the setback to the nearest building.
Yes.
Thank you. Nothing further, Mr. Chairman. Thank you. Oh, I'm sorry, one other thing. Oh, no, that's okay. We addressed, there were comments from other, maybe it's best to just put those on the record with your permission. The fire official had no comment. The police had no comment at this time with respect to this application. And there was a County of Essex Department of Public Works approval that the applicant got dated June 25, 2025, subject to one condition, which is filing the final plat. So I just to round out the record in the Forester, August 11 did have a comment with respect to the tree restoration plan, which probably prompted applicants reference the same and the exemption the same, but I think as was pointed out, it might be a bit premature, that particular comment, and ultimately it may be a qualified exemption, or partial exemption, if you will, from the plan. So nothing further, Mr. Chairman, this time for real.
Any other questions from the board? Like to open it up to the public? Anyone has any questions for the witness? Thanks.
Do you have any further witnesses?
We don't, that concludes our presentation.
And
Like to open it up for public comment? Mr. Pope?
I guess I gotta get sworn in.
Yes. No, it's called.
I think you're familiar with the process. Yes, do you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Name and address for the
All
record,
right,
please.
Jeffrey Feld, 11 Alexander Lane, Short Hills, New Jersey. My comment really doesn't go to the subdivision, it goes to the posture of this application in context of the overlay of the round 3 litigation. And I think, because the application you're going to do today, I think is maybe subject to, because if you look at the 2 exhibits that were put in before A1 and A2, we all know what happened on July 30th, 2021. I was the only resident there. We didn't know the terms. This project is a bonus, one of the bonus projects like that, the dump. The real issue comes back to the ordinance. If you look at the ordinance, that's A2, it says it became effective on the fairness hearing. Because of the litigation of round 3, we know that the agreements won't become final until there's a final order. There's questions in the last 2 weeks whether a final order has been entered, because on September 2nd, the judge signed an order. On the 11th, this was all discussed last night at Township Committee meeting. It was entered on docket, but notice hasn't been given to the public of the entry of that order. Also, this afternoon, RPM has filed a letter to the judge asking what's going on, because the judge did not take into certain drafting comments. So when you approve this, I don't know if the board is giving a blessing or waiving rights of the township, because last night, the township municipal attorney says that the town intends to file an appeal of various orders in round 3. And I'm just saying, be cautious, that you're not waiving rights, that if you approve this, are you ready, and let's say the agreement is voided for some other reasons that have been raised, but we haven't been able to go to the appellate division because there's no final order, that the town or the planning board is deemed to have waived certain claims or causes of action by approving it. That's we're in this procedural crazy perplex, but partly we know because the attorneys who drafted the original ordinance and the settlement, the township terminated the relationships with them. And that, that's one of the overlays on here, but I'm just saying to you, I mean, as to the subdivision that we understand they had to do, and remember, this was approved in 2021, more than 4 years, now they're coming here to do it. But the question is, there might be avoidance of this settlement or agreement, because that's a risk that could be up to the appellate division. So I'm just laying to you some of the procedural history, the factual history that's part of this application. And earlier today, I did send you, Mr. Warner, because the secretary's email address is not on the list, a copy of the quote unquote purported final order that was signed on the 2nd, put on the docket on the 11th, and I would ask that that be part of the record also.
Or did you wish to introduce it as an exhibit?
Yes, I mean.
Now, would it be appropriate to call it O1, or do you want to use a different initial number, a letter than O?
You want to use put F1, I don't care
We
whatever.
put
it is, but
P1 for
P1,
public?
Public one, it's just that the record be clear,
Right.
that.
And do you have a copy of it?
I have only one copy, but I emailed one to you. I'll email, if you email me your address, I'll get it to you tomorrow.
Well,
I have one, I'll give it to you right now.
that'd be
Give me
great.
a second. This is.
what, the judgment?
Why don't you show applicants counsel the judgment, you're seeking to introduce it, I believe it's dated September 2nd, I believe you said?
And this is.
Do you have any objection to its introduction?
I don't.
Do you have any objection to its admission into evidence?
I don't.
Okay, then if the board is willing, the board can take it as admitted without objection.
Without waiving my
Yeah.
position, which is that's not relevant to what you're doing, but I don't think we want to bog down in that in the planning board here.
Understood. Relevancy and any other objections are reserved by you. Understood.
Yes.
And we have that as P1, and it's the September 2nd.
It's the date, the judge signed it on the 2nd, but it wasn't docketed.
No, I think the transcript will reflect the testimony that you've already provided. It's dated September 2nd, correct?
That's correct.
And it is as you say, purports to be a final judgment of compliance and repose?
Based on the representations made last night by the township attorney, I would say yes.
Okay, just want to make it clear what it is on the record, and you, sought its admission, without objection.
All right.
I'm a little puzzled by that because the township attorney submitted the final judgment to his signature. However, let's not bog down.
No, there's another, as I said, there's another story.
But to let Mr. Felt, are you finished, Mr. Felt?
Yeah, I think I just want everyone to have the history and where we
Understood.
are in the posture of how this fits into the larger round 3 litigation, and based on the statements that were made last night by the municipal attorney to the public.
Thank
Could
you.
I address a couple of comments?
With the chair's permission, certainly would be appropriate in my opinion.
Thank you.
Please.
Just a couple of things. Mr. Feld mentioned that the ordinance under which we're proceeding became effective upon the holding of a fairness hearing, which was held many moons ago, and an order entered accordingly. So that took place a long time ago. As he has said, and is now part of the record, there was a final judgment signed. And there may be some squabbling over that from RPM or I don't know who else. But in any event, a final judgment has been signed, but that has nothing to do with whether this ordinance was effective. This ordinance became effective upon the holding of the fairness hearing, which took place a long time ago. The issue of appeal and whether somebody appeals, that doesn't involve us. We settle. We settled with the town and with Fair Share Housing Center. So we're identified, of course, in the settlement agreement as the Woodmont Properties site. So we settle that. Certainly an appeal, in our view, has nothing to do with us. It's issues that impact others. So just wanted to make that clear for the record.
Would be your opinion that regardless, if the board were to adopt the subdivision this evening, the board would not be, the board is not a party to the third round declaratory judgment litigation, correct?
The planning board itself?
The planning board itself.
No, I don't think so. The township, of course, is, and it's
Right.
governing body, right?
Right,
They're the ones who settle.
right.
What about the ordinance that was passed that allows for this subdivision? Is that part of the proceeding that it may or may not be appealed, or may or not be part of a judgment that was signed or maybe not published, or whatever we've been presented with right now?
We can ask the Affordable Housing Council, who is our township attorney, but as far as I understand, the ordinance was adopted, I think the precise time frame was many moons ago or whatever, Mr. Carroll, so we have it, what was it, 2021?
Yes.
So approximately 4 years ago, give or take. Unless somebody demonstrates otherwise, there would have been an appeal period to challenge that ordinance. And either it wasn't challenged or if it was, wasn't successful, from the information I have. So our understanding has to be that we have a valid ordinance we're operating under, unless somebody has some evidence to the contrary.
There was no lawsuit filed. Yeah, again, this was a furtherance of a settlement that the
Right.
town reached, so, yeah. It hasn't been appealed.
Are there any other comments from the public? Okay, open it up to,
Oh, I'm sorry, just say, there'd be a quick summation if Mr. Carroll wishes to make one.
I don't. It's a straightforward application, as you all know. It's just a subdivision, and I have nothing else to say other than to tell you I have nothing else to say. But thank you. We thank you for your time.
okay, and I open it up to discussion from the board. Anybody have any comments or anything they'd like to discuss about the application? Would anyone like to make a motion to approve the application?
I can tee it up real quick if it helps. I believe, well, if it's to approve, it'd be a motion to grant preliminary and final major subdivision approval. There are no deviations, variances or otherwise. And it would be, I'll assume unless I'm told otherwise, with all the conditions of approval stipulated to by or on behalf of the applicant, including the planner's report, the engineer's report, and I believe the other reports essentially had no comments. That would be the motion, if unless I'm told otherwise.
Second.
Oh, no, I can't make it.
I want to, yeah, okay. I move, I so move.
I'm probably doing more than enough already, but I can't.
I see. Roll call, please. Roll call vote.
Corey Miller,
Yes.
Michael Cohen,
Yes.
Jorge Mastro Petro,
Yes.
Deborah Nevis. Yes. Frank Sacamandi,
Yes.
Jonathan Baxter,
Yes.
Chair Gaston Hopper.
Yes.
Thank you so much, folks.
Thank you.
Yes. Thank you.
Okay.
We're on the record. Can I get your honest opinion on my publication? Oh, wow.
Smart. Good marketing. I always have it.
Page 4.
Right, I'm gonna have to write another article, just. Competition gone.
All right, we're moving on to our last order of business tonight, the executive session for pending litigation, case number 223 CV 01833. For the High Center for Living Judaism Incorporated versus the Township of Milburn in New Jersey et al. Mr. Warner, could you please tee us up?
Certainly, we have our resolution to go into executive session, whereas the Open Public Meetings Act permits the exclusion of the public from a meeting in certain circumstances, and it's necessary for the planning board to discuss in a session not open to the public certain matters related to section 12B7 of the Open Public Meetings Act as an exemption therefrom. The public shall be excluded from the discussion. The general nature is the High Center litigation just referenced by the chair. And it's anticipated that deliberations conducted in closed session may be disclosed to the public after a determination by the planning board that the public interest will no longer be served by such confidentiality, and the resolution shall take effect immediately. And as always with a resolution, we need a motion, second, and a roll call vote to go into executive.
Second.
Roll call vote, please.
Corey Biller,
Yes.
Michael Cohen,
Yes.
Jorge Mastro Petro,
Yes.
Deborah Nevis. Yes. Frank Sacamandi,
Yes.
Jonathan Baxter,
Yes.
Chair Gauss Howard.
Yes.